It's my great pleasure to welcome to give this year's Tom Sargant a memorial lecture, which is one of our great events, and here she is giving it for 2020, Dame Vera Baird, Queen's Counsel, and great lawyer and friend, and it's wonderful to see you here, Vera. Are you zooming in from where are you?
I'm just in North London, nowhere exotic.
Oh, really? Oh, well, anyway, it's great to hear you, and thank you, because you need little introduction. You have been a great friend of this organization, and you've had an illustrious career in the law and a long association with justice. Last June, Vera was appointed Victims Commissioner, providing a critical voice for victims in the criminal justice system. Across her career and as a commissioner, Vera has been a fearless advocate for a fairer justice system. Her professional background is known to you. She was a criminal silk. She was a Labour Member of Parliament for Redcar until 2010. She served as Solicitor General from 2007 to 2010. And she most recently served as the Police and Crime Commissioner for Northumbria from 2012 until last year. She was made a Dame Commander of the Order of the British Empire for her services to women and equality. Vera, it's really great to see you. Welcome. Over to you.
Thank you very much indeed. And I'm very pleased to be asked to deliver this lecture as a long-time member of justice, who even did some cases when it was more or less single-handed in fighting miscarriages. And I've been on various committees, notably in 1992, the Justice Committee on the Judiciary, which produced a report controversial for its daring advocacy of a Judicial Appointments Commission. I pay tribute to Tom Sargant, to whom this annual lecture is dedicated, and the amazing work he did for years to free the wrongly convicted. Injustice. The hard injustice involved in those justice cases is not what I'm talking about today as Victims Commissioner for England and Wales. Nobody in the position of victim of crime is going to be wrongly imprisoned. My 20+ years as a defence lawyer are not in the past, they are with me still. Nothing, I say, detracts from the centrality of the defendant's fair trial rights. We can draw a red circle around those rights and improve the role of victims and witnesses hugely without coming near to the circle. But victims can, and they do, suffer injustice from their treatment by the criminal justice system, from disregard to by the agencies to re-traumatization by the process itself. And a quick look at the structure makes it easy to see why. Historians say that originally victims, presumably if they were wealthy enough, brought a claim against an alleged wrongdoer for redress, and that was the criminal justice system. There was the centralized state emerged, it changed to the current situation where crimes are seen as an attack on the state and the public. Responsibility for reacting to them moves from the victim to the court. How to put right the wrong suffered is not the point. The point is punishment and affirming the rule of law. What happens to the defendant will be done for the public good. The victim has lost all centrality. His harm is only the same as the public's harm. There is no right to redress. He isn't a party to the proceedings. Cases can be brought whether he wants them or not, and he can be compelled to testify, but he will go away with nothing. Now at the centre of the court process is the defendant. The prosecution prosecute him, the defence defend him, the jury decide on guilt, and the judge assures that his trial is lawful. The victim may have suffered injury or loss, but he has stopped being the loser, and he has become someone who can tell the court what the defendant did. He is the bystander, the victim in a crime committed against himself. Or slightly differently, as Professor Paul Rock put it in a 1990 publication, victims are now witness fodder for the criminal justice system. This description puts so well both of them. What a barren place for victims the criminal justice system can be. But victims of crime may suffer, an intrusive burglary, wrecking their security, serious injury, the death of a loved one, even relatively small crime can have a big personal impact. They are, and I quote a victims commissioner from far overseas, they are intimately involved from the moment of the offence right through all processes and beyond them into their future life. They will be seriously affected by the process in which they're participants, whether they want to be in it or not. How the state, via the criminal justice system, treats them will represent a key part of their restoration from anything from discomfiture to trauma given to them as a consequence of the crime, which the state has allowed to happen to them. So their interest is quite different from yours and mine in this case. The notion that the state, the prosecution, represents all the public doesn't realistically capture that. We need to acknowledge that special involvement and assure the rights and entitlements that support it. The criminal justice system can't function without victims, so let's acknowledge that they're an integral part of it. I want to set out how the criminal justice system is not currently supporting victims well, and how perhaps repositioning our view of them might help. Shift them from an outsider who can only be an afterthought of the agencies have time from their core role in the adversarial system, put them in the role of a valued participant with separate rights to help them cope and recover. There are some seeds in jurisprudence and practice which might help us to help the criminal justice system to give the victim more justice too. Of course, there are victims' services for victims. Victims support started in the 70s, and the women's movement then emerged, raising awareness of rape, domestic abuse, and creating support services like rape crisis centres and refuges. Now there are men's sports services, talking charities, hate crime charities, and many more. Core victims services are government funded and commissioned locally by police and crime commissioners. Police refer victims to a victims hub following a report of crime. They are there, the hubs, to give practical, personal, emotional support to help victims to cope and recover. Cope and recover is the buzzword in victim care, and of course can include referral on to specialist services. All this has little to do with the criminal justice system. In the courts, witness care units run by police are there to improve witness attendance by helping with the practicalities of getting to court, and at court itself, volunteers from the Citizens Advice Bureau at the moment meet and greet. So there are these service all witnesses, of course, not just victims, prosecution and defence. So there are, in a sense, no connection between the two. There are good witness services. There's an attempt to make the courts function by getting victims there, but not a lot of link between the care of the victim sector and the court. But there are a couple of connections that are very helpful developments. The first is the development of an independent domestic violence advisor role and an independent sexual violence advisor role and an independent victims advisor role. These are professional befrienders, as you have guessed, for the appropriate kind of offence, and IVAs generally look after victims most affected from any kind of crime. But they try to liaise with the court for their victim client, go with them and accompany them as they give evidence. However, ISVAs, etc., are in some courts very welcome. In some, they're excluded completely. And victims then, who've been supported by them for months, have at their most stressful time of giving evidence to do it on their own, perhaps sitting with an usher. That's a mistake, and it's dreadful treatment. And furthermore, data shows that if an ISVA is involved in a complainant, they're twice as likely to sustain their complaint as if there is no ISVA. The other support for victims of court is special measures, started in 1999 to help witnesses who are intimidated or assessed by police as vulnerable to give the best evidence they can. The judge has to agree, but they can include special measures testifying from behind a screen, across a live television link from a room outside or elsewhere, special measures have truly meant that many victims and witnesses who would probably have been unable to give evidence can now do so. But as with ISVAs, etc., only being patchily received by the courts, so special measures are not done universally well. The police miss out a lot of people. Victims hubs certainly say so, and research reported in the Criminal Law Review in 2006 showed that whilst police assessed 9% of witnesses as potentially vulnerable, use of a simple but professional screening questionnaire discloses that 54% are potentially vulnerable. Now, having rights to an ISVA or to special measures that aren't properly implemented somewhat reflects what happens with the Victims Code, which is, of course, a document giving entitlements to minimum standards of service in the criminal justice system. And there are 12 key rights. Note first, these are not enforceable, and so actually they're not rights. Secondly, they're not expressed as rights. Right 6 is about getting information and communication, and says in parts, where police or CPS are considering an out-of-court disposal, you have the right to be asked your views and have them taken into account. Where this isn't possible, the police or the CPS will tell you why. Further in Right 6, in a particular category of harmful cases, if the CPS are not going to charge, you have a right to be offered a meeting, unless the CPS decides that a meeting should not take place. They will tell you why. And my rights seem to be told why I can't have my rights. Part of Rule Right 8 is when attending court to be able, it says, to enter through a different entrance to the defendant and wait in a separate waiting room. It continues, some court buildings don't have separate entrances for victims nor separate waiting rooms, but where they're informed, the HMCTS will, in effect, do their best. Bluntly, family members of somebody who's killed come to court and we can't guarantee them a right not to sit next to the defendant in a waiting room. These, of course, are not rights. If it was a right to have a separate waiting room, one would have to be provided. They are moulded around what the agency can deliver and not around the victim. Let me highlight a couple of the code rights I haven't yet mentioned. Rights 3 and 6 are to be provided with information about the case and updated when important decisions are taken. Right 4, to be referred to victim services. Right 7, the right to make a VPS, a victim personal statement. Right 9, to be given information about the outcome of the case. In February, my office analysed victims' data from the CSEW. The Ministry of Justice collects, well, the CSEW collects victims' data, but it's not analysed by the MOJ. It hasn't been for many years, so we now started to analyse it. Most victims feel the police treat them fairly and with respect, is how it opens. That's good. But more than half said the police did not keep them informed about progress in the case, and that's a significant drop in satisfaction over the past 5 years. That's right 6. But most victims say their satisfaction with the police was really their initial contact with the police. Over a third grew quickly dissatisfied with the way the police handled the case. They took too little action and they did not communicate with victims. Not communicate, not kept informed, rights 3, 4, 5, and 6. In the year ending March 2019, only 11% of victims got any information, any advice, or any support following an incident of crime. In cases where the police came to know about an incident, just 10% of victims had contact with victim services. So remember, they're run by PCCs. Police are intended to refer victims to victims services. In some areas, there's an opt-out system, so all are referred unless they say they don't want, but only 10% are in fact referred. This is right 4. And 36% of victims were dissatisfied with how the criminal justice system overall dealt with their case. These are rights under the Victims Code, but only 20% of victims of crime who've been involved with the criminal justice system in some way have ever heard of the Victims Code, and I presume of any of its entitlements. In my office, we do an annual survey, my predecessor did, about the victim's personal statement. Right 7 is to be told about it and helped to make one. For the 6th year in succession, fewer than 1 in 5 victims recall being offered a VPS. And this fell to 1 in 7 in March 2019, when I made my first report. Of those who did make a VPS, only 46% felt that it had been taken into account anywhere at all. And that's the lowest level of satisfaction since we started counting them. So that's 8 or so out of 12 key rights that are not being delivered. We have personal complaints to the office very frequently that tell the same stories of failure and consequently poor treatment. In 2009-10, Ministry of Justice stats showed 67% of victim witnesses who'd given evidence would do so again. CPS research in 2016 showed that only 53% of people who'd been a victim witness at court would do so again. So count it the other way, the 47%, nearly half of those who'd been a victim witness at court wouldn't go again. Under the Victims Code, those suffering the most serious crimes are entitled to enhanced rights, implying greater care, like earlier contact about decisions. Rape complainants are in that category. Yet our recent survey of rape complainants show that far from receiving any enhancement of service, many complain about the CJS as virtually a hostile environment. 491 rape complainants responded to our online survey. Many of those who reported to the police say that they felt disbelieved and judged. 95% of respondents who didn't report to the police said it was because they thought they would be disbelieved. 88% of this same group of non-reporters said that disbelief will be because of my gender, my sexuality, or my lifestyle. You may think the ones reporting sadly prove the reservations of the non-reporters to be correct. CPS decisions to drop cases were described as devastating to receive, and some felt that they were unjust because they thought that avenues were not pursued, evidence not considered. Only 14%, 1/4, agreed with the statement that they would get justice by reporting an incident to the police. Worse again, 75% actively disagreed. The most recent Home Office figures show 43% of sexual offence complainants won't proceed with their case. 49% in personal violence won't proceed with their case. Across every kind of crime, 25% of cases in the criminal justice system have been stopped because complainants withdrew their support. This is triple the percentage of those withdrawals since 2014-15. So what we're seeing is a failure to deliver victims' code rights and give services, and thus poor treatment, contributing to low confidence in the criminal justice system. I won't go into court backlogs caused by cuts and made worse by COVID, which will also deter victims without any doubt, because the failings I've set out long predate COVID, and they will continue long after it, and we will continue to lose victims from justice unless there is a change. One thing I should reference, and it's hard to know where to put it in this address, is the question often raised with me, who's a victim? In a trial, of course, the right term is complainant. However, in most criminal trials, a complainant is undoubtedly a victim, someone who suffered harm, unlawfully inflicted, and what's in dispute is whether the accused did it, had the necessary state of mind, or whatever. But in some trials, the question is, was there a crime? For instance, in rape, if the defence is consent, or in an assault, if the defence is self-defence. This cohort seems to fog the issue of support for people who are victims of crime. Can we look at this group briefly? People are demeaned and damaged by being beaten or being used as objects by others, and they're often ashamed to talk about it. This criminality, the two categories we're dealing with, is traumatizing, and many will need considerable help and support to cope and recover. Rook and Ward, the textbook on sexual offences, sets out the range of psychological reactions following a sexual assault, which include anxiety, self-hatred, self-blame. 94% of people have post-traumatic stress disorder by 12 days after the offence. 51% had post-traumatic stress disorder at some time after it and still had it years later. Also, many rape complainants have already been victimised. Again, much research mentioned in Rook and Ward shows that people with a history of childhood sexual abuse, mental health, or learning disabilities are more likely to be raped. Predators seem quite good at spotting the vulnerable. It's not appropriate for you or I to deny support to people who may well be victims. We can't decide whether somebody is a victim or not. And it isn't possible to wait until the trial's over to decide if this complainant is a victim affected by rape or by a beating in a fight they didn't start. If it's correct, they'll need support in the CJS now. The only possibility is to give them their entitlements now. I think actually we took this decision many years ago when we allowed special measures automatically for all rape complainants. But this is the only default position available, and it should not fog determination to ensure rights and support to victims of crime. So next year, there'll be a victims law, a chance to tackle the dilemma that rights aren't working, aren't enforceable, and are only rights as long as the agency wants you to have them. Recently, my office spoke with some government officials looking for targets for victims. I don't entirely know why. One target proposed was a 50% increase in awareness of victims' rights. Of course, we said, well, given that awareness is now 18%, that would come to 27%, so low as to look a bit silly as a target. They said they had had a real battle with the police and the CPS, even to get agreement to that, which you may think says it all. Police, CPS, courts, good public servants will try to help, but they don't think it's their role in the criminal justice system to deliver victims' rights. In 2016, my office researched what works in supporting victims of crime, looking at evidence here and abroad, just to kind of reassure you and then unreassure you at the same time. Victims do seem to want, more or less, what's in the Victims Code. The unreassuring bit is, of course, as I've said, they don't really get it. We found people wanted information, communicated well, including an understanding of the criminal justice system and updates on the decisions in the case. They want collaborative working across criminal justice agencies. They want professional victim services. And most importantly, they want procedural justice. A procedural justice requires a respectful acknowledgement that wrongdoing has happened, listening empathetically, letting them know their entitlements, taking reasonable action. Victims place as much value on procedural justice as they do in getting the right verdict. A core of why these rights are so important is that they are restorative. They tell people that contrary to having been demeaned by their criminal treatment, they are valued by society, and the CJS on society's behalf treats them with respect. And what works shows how remarkably little it takes to make the criminal justice system work for victims. So these rights are very important in many ways. The care of victims in these simple ways is the other half of the justice to be delivered by the system. And it's clear that the victims' law should make the code statutory and the rights enforceable. Most other adversarial jurisdictions seem to have a specific complaints resolution system for breaches of victims' rights. Here, each criminal justice agency has its own separate complaint system, not specific to breaches of victims' rights. And a victim can only go beyond that if their MP agrees to support a complaint to the Parliamentary Ombudsman. Not surprisingly, with that kind of threshold, a Parliamentary Ombudsman gets about 7 complaints a year. So we should follow Australia, Canada, and the others and put a duty on all criminal justice agencies. 1, to implement the Code of Rights, rewritten as rights for the victim and not concessions to be made, if possible, by the agencies. To provide accessible and transparent complaint systems specifically for victims about the code, and remove the requirement for an MP so that the Ombudsman becomes the appeal process. What form the redress for breaches takes may vary. Discuss. There are MPs who think that failing to deliver victims' code rights should be a disciplinary issue in each one of the criminal justice agencies, in all of them. There's a need also for a framework for annual compliance monitoring to protect victims essentially from needing to make complaints about code breaches. Police and crime commissioners are asked to do that locally, though data issues have meant slow progress. Nationally, whilst complaints should go to the revamped Ombudsman, the overview of compliance should come to the Victims Commissioner. Statute requires me to keep under review the performance of the Victims Code, but it gives me absolutely no power to do it, to bespeak information, to require a response to recommendations. So that should change to provide a systematic annual overview with recommendations to the Ministry of Justice. This would be in the Victims Commissioner's annual report, which from this year, I'm very pleased to say, is not just to be sent to the Ministry of Justice, but will be laid before Parliament. Enforcement discipline on its own to implement the code is important, but it's a shame. The police prosecution courts, I believe, just think it isn't their job, and they would support victims if they saw them as key participants. And I suspect if the government saw them as key participants and gave the agencies extra resources specifically to deliver rights to this side of the case. So the participant victim is an interesting idea. The victim in their own case, as I've said, has a very different interest from yours and mine as members of the public wanting a good criminal justice system in a tangential sort of way. The late Lord Steyn, with the approval of other members of the House of Lords, said in an Attorney General's reference of 1999, serious crime should be effectively investigated and prosecuted. There must be fairness to all sides. In a criminal case, this requires the court to consider a triangulation of interests. It involves taking into account the position of the accused, the victim and his family, and the public. That was cited by another constitution of the Lords in the Crown against H in 2004, and Lord Steyn himself reiterated in the Crown against A number 2. People remember this is the rape case just after the Human Rights Act that looked at section 41. And Lord Steyn said it's well established that the guarantee of a fair trial under Article 6 is absolute. A conviction obtained in breach of it can't stand. The only balancing permitted is in respect of what the concept of fair trial entails. Here, account may be taken of the familiar triangulation of interests of the accused with the victim and society. In this context, proportionality has a role to play. Not surprisingly, he puts it rather better than I do. Victims, of course, can't be parties to the proceedings. That will be completely inconsistent with the adversarial system and involve them in taking decisions they aren't qualified to take, and it isn't suggested. But triangulation recognizes separately in a proportionate way that the victim has a participatory role to play, closer than we, the detached public. There are some international requirements founded on the UN Declaration of Basic Principles for Victims of Crime in 1985 that somewhat back the recognition of separate victims' rights within the criminal justice system. Principle 6 of that declaration says judicial processes should allow the views and concerns of victims to be presented and considered in the proceedings where their personal interests are affected. European human rights case law, especially in Duurson and the Netherlands, also observing that Article 6 fair trial rights under the Convention don't reference victims, but that their life, security, liberty, or privacy rights might be at stake in a case and are protected by other rights. The court said the principles of fair trial require that in appropriate cases, those interests are balanced with those of the defense. In other jurisdictions, in Canada, Australia, the USA, Northern Ireland, we've done a bit of research. We found the status of participant in force in Victoria, Australia, and elements of it in the state's process in Manitoba in Canada and in proposals in Northern Ireland. The Victoria Law Reform Commission in 2016 recommended the adoption of this concept. The role of the victim, it says, should be conceptualized, understood, and implemented in accordance with modern jurisprudence. In the modern trial, there is a triangulation of interests, those of the public, the accused, and the victim. Without that triangulation, the interest of the victim in the criminal trial is not that within, I beg your pardon, that triangulation. The interest of the victim in the trial is not a party, but it is a participant. And this is put into the Victims' Charter Act in Victoria. A victim of crime has an inherent interest in the response of the criminal justice system to that crime, giving rise to the rights and entitlements set out in this act and acknowledging the victim's role as a participant but not a party in all criminal proceedings that concern them. Redefining the role is intended in Victoria, as it would be here if we did it in the victims' law, to be a practical, not a theoretical step. It's a revisioning of the role of victims so that their rights flow from the participatory position. So the victims' law would set that position out, making statutory the right of victims to that role with the set of enforceable minimum guarantees which allow them that participation. And it should, of course, after all these years, provide for education and training programs for criminal justice professionals to make familiar that role and the need to assure those rights. Now, for many victims, participation will be satisfied by information and support, but for some, it will involve being able to challenge decisions which directly impact on them. I mean, we're quite used to this. The police and the CPS have victims' right to review schemes, which let a complainant request a review of any decision which would put an end to a case therein, not to charge, for instance. These are an important step toward a participatory voice for victims in the criminal trial process. This year, a judicial review established that the CPS, Victims' Right to Review scheme, has in it a fair opportunity for a victim to make submissions to procure a favourable decision on the review and the corresponding obligation on the decision maker to consider them. The CPS had argued that the VRR scheme only allows someone to request that they review it, but not to influence the outcome. The CPS don't have to invite representations, and this isn't a right, but if the opportunity to make representations is taken, they must respond to the representations made. This is a strengthening of the victim's role in charging. Remember how devastating rape victims find decisions not to charge? It follows the victim's right to a voice through the victim personal statement to be heard on sentencing. Similarly, the victim has a voice post-sentence to be heard via a victim personal statement at parole hearings. Nobody asserts that because it's their case, the participant's view is determinative. It's the authority's role to make the decision. But many victims have a deep need where they're intimately involved to be heard. And frankly, many have a lot of sense to speak as well. A victim's right to privacy is important. Sometimes victims' rights and the stance of the state don't just differ, they clash. This is a case on point, Article 8 rights. Prosecutors who find any private document of the victim which they think might undermine their case or assist the defence must disclose them. However, the triangulation of interests recognised by the House of Lords and recognised internationally allows the victim a voice to ask for a proper balance to be struck, taking into account their privacy rights. This is an interest not otherwise capable of being represented, and it may be a very, very important one for the victim. Nor does it undermine the accused, since the finding that the balance favours the victim would merely rule out an unfair forensic advantage, not a defendant's legitimate right. This obviously links to recent criticism of the police and CPS approach to mobile phone data and confidential documents like health records. The judicial protocol on disclosure recognises victims don't waive the confidentiality of their medical records or their right to privacy under Article 8 of the ECHR by making a complaint against an accused. The court, as a public authority, must ensure that any interference with the right to privacy under Article 8 is in accordance with the law and is necessary in pursuit of a legitimate public interest. General and unspecified requests to trawl through records should be refused. Confidentiality rests with the subject of the material, and the subject is entitled to service of an application, of the application, and has the right to make representation. Evaluation currently underway of a pilot of legal representation for rape complainants to challenge, amongst other things, disclosure of private documents suggests that sometimes when the issue of privacy is raised, the CPS just drop the case. That's despite the case of the Crown Court at Stafford, which gives a victim a right reflected in that disclosure protocol to be heard on any subpoena for confidential material of theirs. I just don't let it go to subpoena, I suppose, is the attitude. And it is an example of the need to set out in statute the right of the victim's voice to be meaningfully heard. However, police and CPS do also seem from time to time in this evaluation to be acknowledging that the challenge by the victim's legal representative has been beneficial, and that in earlier cases they had sometimes, they now think, over-demanded private material. I mean, both the Information Commissioner and Her Majesty's CPS Inspectorate in reports this year have agreed that the CPS has over-demanded private material during their recent history. And this, of course, has contributed to criticism of the CPS. But the prosecutor in the adversarial system cannot represent the interests of the victim in a disclosure issue. And so it's partly true that they are blamed for not doing what they can't do. So as an organisation, they, and similarly the police, can benefit from the recognition of a separate interest which needs to be properly represented. So in 2005, the Labour government proposed legally aided representation for victims in rape and in homicide and domestic violence. In his review of serious sexual offences cases in Northern Ireland last year, Sir John Gillan endorsed legal representation inter alia on disclosure of private records. And in 2014, this Ministry of Justice had a similar proposal. Those clearly need to come to fruition in the victims' law to shore up the enforcement of some of these participatory rights. So nobody could suggest that this is a fully realised new vision of the victim's role. But there is a need for victims to be recognised as having an inherent interest from the day of the crime throughout the criminal justice process, and to be given rights that respect and support that role. We need to bring change if the CJS is to help victims toward recovery and restoration, and also, frankly, if we're to have a functioning criminal justice system. There's firm grounding in English and Welsh jurisprudence and in some Commonwealth criminal law for recognising those interests and acknowledging them as separate from the state, which can't fully represent them on all occasions. It's cheering that this jurisprudence is strengthening victims' voice in the criminal process separate from the state, both Lord Steyne and the High Court in the VRR case, because that makes clear that recognising this role involves no oversteering into the defendant's rights, just the concept of fair triangulation. So as the victims' law approaches, we could let this idea, now in law in Australia, spark off some ideas and work on it more to bring improvement. Perhaps a Justice Committee to consider it? Would it be controversial like the 1992 one? Anyway, if that's what we do, I think we shouldn't do it till the end of lockdown or even the start of vaccination, because we definitely need to begin it with a short trip to Australia. Thank you.